we want to get some legal analysis of what we've seen so far in the trial and the arguments that we can expect to see today. I want to bring in Keir Dougall. Keir, thank you so much for joining us this morning. So we talked a little bit about the argument that we heard yesterday. Good morning. We spoke to Deborah about the fact that the impeachment managers wanted their jurors, their audience, to feel that Donald Trump could be a clear and present danger moving forward. But they also wanted to focus on what they say was the former president's lack of remorse and what he didn't do. Why is that a key part of their argument?
Well, it's key because if you establish, certainly during the riot, that former President Trump understood the magnitude of the threat to the Congress, if you can establish that he understood that threat, and that he wasn't surprised, that he wasn't remorseful, that he didn't take immediate steps to stop it, that's very strong evidence of his state of mind, of his intent, of what he wanted. And so, then as a House manager, as a prosecutor, you argue, okay, well, that lack of remorse after the riot had started shows that he wanted the riot, and he wanted it beforehand as well, which explains why his speech was given the way that it was given. So it's of a piece of the argument about what the speech, what all of that conduct leading up to the rally on January 6th for the march. What that all meant and what was in President Trump's mind is one of the things that the managers have to argue is that, what you heard in the speech and what you saw in the introduction, the claim where he said, go march peacefully and patriotically so your voices can be heard. They have to argue that he didn't really mean that. They have to argue that the fiery political language, fight like hell, wasn't figurative speech, that wasn't just a fiery political speech, that it had become something else, that it was an actual call to violence. And so it's, that's evidence. If you can establish that he understood what was happening afterward and wasn't surprised and wasn't remorseful, it shows or tends to show that that's what he wanted.
So overall, what were your sort of biggest takeaways when it comes to the prosecution's arguments? Obviously, even Republicans were impressed by them, particularly when you compare them to the impeachment, the first impeachment. We saw, in the first impeachment, we saw a string of witness testimony, a lot of witness testimony, none of that in this case. Your biggest takeaways and sort of compare and contrast.
Right. So I thought the arguments were excellent by the House managers. And I think they were very careful to focus on who their audiences are. And they really have two audiences. One is the 100 senators in the chamber, and the other is the public. And so, they argued about what they believe the evidence showed. And even though, as I think Deborah mentioned earlier, it's a very steep uphill climb based on the reporting, that they will be able to convince 2/3 of the Senate that he should be convicted. The other important, I think, aspect of the presentation is speaking to the public and explaining to members of the public who may have this sense of grievance about the election that no, the election, all of the evidence is that the election was fair, that there wasn't fraud that infected and affected the election, that we have democratic processes, and that resorting to violence is simply, it's un-American under these circumstances, and it causes all kinds of damage to, an injury to effectively innocent victim law enforcement officers who are simply trying to enforce the law. So, I think even if they have an extremely steep uphill climb of convincing the jurors and judges in the Senate, what their very effective advocacy does is remind Americans who might be unsure about this that assaulting the government when you're unhappy about the results of an election It's just simply un-American. It's not what we founded our country upon.
I think it's a good reminder that there are two audiences here, and the rest of us, we are that second audience. House managers tried to maybe undercut what they expect will be a counter argument from the defense, a pre-buttal, I heard it be called. I want to play some sound.
Incitement to violent insurrection is not protected by free speech. There is no First Amendment defense to impeachment for high crimes and misdemeanors. The idea itself is absurd. And the whole First Amendment smokescreen is a completely irrelevant distraction from the standard of high crimes and misdemeanors governing a president who has violated his oath of office.
Because President Trump wasn't just some guy with political opinions who showed up at a rally on January 6th and delivered controversial remarks. He was the President of the United States.
So what's your expectation for the defense here? Is it just really do no harm?
Yeah, so I expect them to continue to argue this First Amendment issue. I expect them to continue to argue the jurisdictional issue as well. But on the First Amendment argument, I believe that the managers have it correct, and that they are joined by the vast majority of scholars across the political spectrum. Look, when the president takes the oath of office and swears to protect, preserve, and defend the Constitution, the president takes himself out of the role of an ordinary citizen. An ordinary citizen would have the right to say all sorts of things that would be inconsistent with that oath of office. And the manager Raskin gave some examples about, expressing fealty to a foreign adversary, about, other things. You can do those things, even if they're repugnant to most of us. You can do those things with the protection of the First Amendment if you are an ordinary citizen. But once you agree, you voluntarily accept the oath of office of the presidency, those things are, you no longer have the right to say things that would violate that oath. So that's the first problem. The second issue is, the First Amendment carves out and makes sure that some speech is legal, but a high crime and misdemeanor does not require illegal conduct. It's language that's borrowed from England from a couple hundred years ago, but the framers did not mean that you had to actually commit a crime. So you can give lawful speech and still commit an impeachable offense. And then finally, even an ordinary citizen couldn't give a speech that would incite imminent lawful or imminent unlawful action. You cannot, even as a private citizen, incite a riot. So for all those reasons, the First Amendment defense isn't going to hold up. But I expect the defense team for President Trump to continue to make the argument.
Keir, really, really quickly, sort of a yes or no answer, because we're running out of time. We heard last night that 3 Republican senators met with the defense team to talk strategy. They are the jurors in this, to remind everyone. Is that constitutional? Is that okay?
Well, under these circumstances, the quick answer is yes. But in an ordinary trial, in court, in a criminal trial in court, the jurors would not be kibitzing with the defense counsel or with the prosecutors about trial strategy in the middle of a trial. That's just not what would happen.
All right. Thank you, Keir. Thanks for being fast. We're going to dig into that a little bit more later on.